Hey, everybody. Welcome to the Santita Jackson Show on AM 950 Radio, the voice of progressive Minnesota. It's a joy to be with you today. I want you to meet us here at AM 950 Radio and am950radio.com, but also on the Santita Jackson Show YouTube channel. The Santita Jackson Show YouTube channel. Please like and subscribe. Click the bell so that you can get notified whenever we come on live, and we do it every day. And so I want to see you. I want you to be my friend, and please join me over on Facebook on the Santita Jackson and Friends page. Many of you continue to go to the Santita Jackson page. Don't go to that one, please. Go to Santita Jackson and Friends. That way I can pull everybody in. Facebook has a rule that once you reach a certain threshold, they start purging your members, and they've been doing that to me for years, but I have to keep that page in order to get the other page. So if you would, please go to Santita Jackson and Friends. I've never figured out the rules, but they are what they are. So let us talk about Donald J. Trump, the former president of the United States. Dozens of states have been filing legal actions to keep him from being placed on the ballot. And so the Colorado case got to the Supreme Court. And what happened at the Supreme Court today, unanimously, at least that is the bright headline, all of the justices said you cannot use the 14th Amendment to block him from being on the ballot. So what do you think about that? Now, when you really break down, we're going to get you to break it down for us, Attorney Mark Fancher. When you break it down, well, the liberal justices kind of lined up over here. And, Amy Coney Barrett said, look, we don't want chaos, hold it. Let's just, and everybody, I think, as you read the decisions and the writings of the other justices, they are clear on the political atmosphere in which we are living. We're a sharply divided country, and everyone deeply, deeply, deeply feels something about this election. And I think it goes past President Biden. It goes past former President Trump. It really has a lot to do with how people are feeling. People are really struggling in America. The average rent is $2,000 a month. People are living from payday to Monday, if you're lucky enough, blessed enough to have a payday. People are struggling. When you think of the University of Chicago having tuition for an undergraduate of $100,000 a year, who can afford that? Many state schools are unaffordable. Many young people are taking the option of going to junior colleges so that they don't have to pay as much in four-year universities. There is a lot going on. And then student loan debt, as much as President Biden has tried to get it forgiven, the banks just won't relent through the courts. Because indeed, Terry O'Neill, this is the most corporatist court that we have had since they have been measuring these things. And it's a business-friendly atmosphere. Our legal system is. It protects businesses and not people. In fact, corporations are people. You help me to figure that one out. So we've got a lot to talk about today. What happened in Washington, D.C.? Well, something momentous. Now it appears that these dozens of lawsuits that have been filed to keep former President Trump off of the ballot, seems like it's not going to work. It seems like he's going to be on the ballot, not only for the primary season, but in November, should he become the nominee. So let's talk about it. What does it really mean? Dwight McKee, noted social scientist, senior advisor to Dr. Cornel West in his presidential bid. He's also the dean of Ma'afa Redemption Project here in Chicago, helping young people to really think of themselves in the best way and get on their feet. The national president, the former national president of the National Organization of Women, one of the most renowned civil rights lawyers in our country, someone who's been fighting for women's civil and human rights and really helping us to understand how all of our rights intersect and how we all have skin in each other's game. Thank you so much for the work that you have done, Terry O'Neill. And of course, we're going to start with you, Attorney Mark Fancher, one of the great civil libertarians, author, opinion writer, one of the greatest minds that I've ever known. But all of you here have so much to offer. And so let's start with this opinion. It's a unanimous decision. Mark Fancher, what did they decide?
Well, I have not had a chance to read it, much less digest it. But from what I understand from the reporting, uh, what they did is that they did rule that Donald Trump will be allowed on the ballot. And it was an opinion that the plaintiffs described as one that avoided uh, the any ruling as to the particular claims that were of most significance and most importance to them. Ultimately, the court concluded that though this provision exists in the 14th Amendment, and it's a provision that was intended originally to ensure that after the Civil War, those who had been part of the Confederacy or who had waged insurrection against the United States would not be in a position to try and become president and subvert it from that position. That it is a provision that actually is one that the courts are not authorized to use for purposes of disqualifying someone. That is a role that's limited to Congress. I also understand that what they ruled is that uh, what that they did not address is the question of whether, in fact, Donald Trump engaged in an insurrection. That question was left unaddressed as well.
Mm.
So whether anyone wants to make something of that and attempt another challenge to him, given that the court has not specifically precluded a challenge, um, if not through the courts, then otherwise, I guess is something that we have to wait and see about. But I must confess that from the outset, I've not been a big fan of the idea of trying to keep Trump off the ballot. Um,
Why?
I'm not a fan of his. I think he's an idiot and has no business having his hands on the levers of government. I think that's extremely dangerous. But at the same time, I think that wading into those waters can have unintended consequences. If you want to start disqualifying people from running for office because they have engaged in an insurrection, uh, it raises questions about really, at least under law, how is an insurrection defined? On the one hand, you can try and disqualify him for having encouraged what happened on January 6th, but left undefined, that leaves the door open for someone to try and disqualify someone for having participated in a Black Lives Matter demonstration or to have engaged in some other, labor, uh, struggle or something else that traditionally has been regarded as legitimate First Amendment activity. And, there is no definition that I know of as it relates to this provision with respect to the term insurrection. What does that mean? That's left open, and I think that whether Trump's lawyers made use of it or not, I think it was at least something contemplated with respect to his due process rights under the 14th Amendment. If he's being accused of that, then he should be entitled to the opportunity to come in and to challenge the allegation or the accusation that he's engaged in an insurrection. But you can't really do that if you don't know how the court defines that term. So I think that that's a real concern. The other concern that I have is a more practical one, and that is that we have already seen what his supporters do when they feel that they have been robbed, when they feel that they've been deprived of an opportunity to have the person that they want as their president. And I think that if January 6th is what they were prepared to do, when in fact uh, there were no problems with the election, if in, when there was in fact a legitimate election that resulted in Joseph Biden being elected as president, if that's what they were prepared to do when he really lost, then what are they prepared to do if in fact he is not even given an opportunity to be placed on a ballot. And for them to even have the opportunity to go and to register their vote, to make it clear who they want to be president. And so it's not really so much a fear of their actions, but it's really just more a concern of just the ongoing turmoil that would result from that in the wake of any election that barred him. And I've always said that if the majority of the people in this country honestly and truly want Donald Trump as their president, then they should have him. They really should. And I don't really like the idea of preventing people from voting for the person that they really want to have the president. I know that that's something that I want.
Well, I mean, because I don't want anyone preventing me from having the same space. But how do you read this opinion, Attorney Terry O'Neill?
I think on the one hand, it's a very cynical opinion, saying that Congress is the only entity that can enforce this section of the 14th Amendment, knowing full well that Congress has been frozen for decades and is likely to remain frozen for a long time now. That's essentially saying that we don't like Section 3 well enough to have it be enforced. I think clearly it could be enforced at least by a federal court. So I think that the 5-person majority was deliberately setting it up so that this section can't be enforced, at least not against their guy Donald Trump. As much as I see what Mark Fancher is saying, I do see where you're going with that. I think there is another danger that we face in this country, and that is that if we don't follow the law. Now, remember, courts have a responsibility to interpret the language that is used in a constitutional provision or in a statute. That's their job, is to interpret the word. So the court gets to say what insurrection means in the context of Section 3 of the 14th Amendment. And we have massive amounts of factual evidence showing what Trump did. Nobody has ever done, no president, no sitting president has ever done what Trump did. I see that vengeful, unfair prosecutions of progressive activist organizations are possible, but there are no facts to back up any suggestion that, for example, Black Lives Matter or the George Floyd protests came anywhere near what the president of the United States tried to do. It was a 7-pronged approach to keep himself in office because he felt like he could lose the election. And let's be clear, Donald Trump has lost not one election for president, but 2. Hillary Clinton defeated him in a nationwide vote by 3 million votes. Joe Biden defeated him by 7 million votes and the Electoral College. So this is a man who knows he actually can't, that he knows that getting elected president is a very steep hill for him to climb. And he's willing to use violence and incite his people to violence in order to keep power. And the 5 members of the Supreme Court that ruled on this are willing to let him do it and take it completely out of the courts. I just think it's a poorly reasoned decision, frankly.
Dwight McKee, your thoughts?
Well, I'm closer to Mark on this issue. Yes, I think a couple of things. I think first, the 14th Amendment, the original law, was written for people who had actually left the Union, seceded from the Union, and declared war on the Union, which is a lot more defined as an insurrection when you declare yourself a different country and you attack the country you left. Then this case, which was very arbitrary, he had not been convicted of insurrection. It was the conclusion of the attorneys at the state level. They would make that determination. And you open up a Pandora's box where anybody, anywhere then can make that accusation about somebody who they were trying to take off the ballot. Florida had already begun to talk about charging Biden with insurrection and challenging his right to be on the ballot in Florida. Texas was talking about same thing, challenging Biden's right to be on the ballot in Texas. And you would really open up a Pandora's box that anybody anywhere could decide. I mean, just following the logic, Dr. King had been defined by J. Edgar Hoover as the most dangerous man in America when he was alive. Jesse Jackson, who had taken his place, who had bought into the philosophy of Dr. King, ran for president in 1983 and 1984. Well, the argument could be that because he was a disciple of who was defined by the FBI as the most dangerous man in America at the time, that he was in the tradition of the insurrection and he had no right to run. And you could take that on and on and on and on. And so, I think it was a very dangerous precedent. The other thing I think it may have done is save us from a potential civil war. Because as Mark was alluding to, is that Trump's crowd, who don't take well any notion of him having run and lost. Imagine if they believed that they had taken his option to run off of the table out of some government conspiracy. And then they who already have this mindset of themselves being the patriots and the government being the insurrection, creating insurrection. They then would have, I think, declared a war on the government, having seen themselves as trying to save democracy in the Federation, saving, the United States of America, and seeing themselves as the ultimate patriots, given rights by the Constitution, who tells them if that's how they see reality, they don't just have the right, they have the duty to revolt. And once you read that, that you feel like to not then fight the good fight is unpatriotic. So I think they may have saved ourselves from a whole generation of bloodshed.
Terry, why don't you react to this, you and Mark and Dwight, because Amy Comey Barrett, wrote a concurring opinion, I guess you would call it that, yes, which was interesting. She said this suit was brought by Colorado voters under state law in state court. It does not require us to address the complicated question, something you went to, Mark, whether federal legislation in the exclusive vehicle through which Section 3 can be enforced. The majority's choice of a different path leaves the remaining justices with a choice of how to respond. The court has settled a politically charged issue in the volatile season of a presidential election. We have to remember Super Tuesday is tomorrow. And she continued, particularly in this circumstance, writings on the court should turn the national temperature down, not up. What do you think she meant by that, Terry?
Well, I think that she sees kind of maybe I didn't read the thing quickly enough, deeply enough. I read it too quickly. But I think there is some concern, perhaps, on her part that using violence to remain in power will, if it goes unchecked, and if Trump is not held accountable, and many of his people are being held accountable, they're going to jail for January 6th. But he himself, who was adjudicated by the state court in Colorado based on evidence that he incited the insurrection, if he cannot be held accountable for his actions, then we have a lawless state. Then what we have, and I think what we're going to do is encourage his supporters to simply not accept any outcome other than Trump wins. Doesn't matter what the count is, doesn't matter who vote how. It's just, if Trump doesn't win, these people are going to use violence to install him. And we know that they've done it before. We know that they will be better organized to do it again. And now we know the Supreme Court is really not willing to do very much to stop them. And so that's where I see, a real danger for this country. And look, I live in Tennessee, where the legislature, with zero justification, expelled 2 African-American legislators from the House of Representatives, and are now considering a bill that says if anyone gets ejected from the House of Representatives for violating these really bogus, crazy rules of decorum that have been changed.
Kind of nebulous rules.
Yes, if you get expelled, you can't come back and serve. You can't. Your people cannot even elect you to come back and serve for 5 years. Is the new bill? It has not passed and been signed into law. All I'm saying is we have an ideologically driven part of our politics that disregards facts. They disregard equity. They disregard, they don't want to play by the same rules that they set for other people. And we need leadership like the Supreme Court to recognize that and do something about it. And I think in this decision, the Supreme Court has said, well, let's let frozen Congress, which will never unfreeze for at least another 2 decades, let's let them deal with it. It's just a bad decision.
Well, Mark, is it the obligation of the court to turn the temperature down and not up?
I don't think so. I think that their obligation is to follow the law and to rule however the law says that they should rule. I think, and that has been my frustration throughout my career, is that there have been occasions when, more than a few, when I've had cases where the law clearly says that, what the outcome should be, but the court gets involved in trying to consider other things that are extraneous to the legal question and trying to come up with an outcome that is going to, have some, from their perspective, favorable type of a result. And from the perspective of my client, it's a miscarriage of justice. So no, I don't think that's their role. But I do think that regardless of what their thinking may have been in connection with this ruling, I still am glad that it came out this way for this reason. While I agree with Terry's concern about accountability and the need for Trump to be held to account for his crimes on January 6th, I'm just not so sure that the right way to do that is to disqualify him from running for office. I think that implicit in Section 3 is the idea that there has already been a determination made that someone has engaged in insurrection. And that having been established, that disqualifies that person from running for office. I think in Trump's case, although we know that he engaged in it, that's something that just from our experience and from everything else, that, it's just something we just know. I don't know that there has been a finding to that effect that could be used as the basis for depriving him of any right or opportunity that he might have to anything. And I guess I go back to what I was talking about earlier in terms of if we allow that, then it extends to other situations. There was and there still is a movement in this country that generically is known as the Republic of New Africa. And the basic concept is that because historically people of African descent dominated the Black Belt, states in the most southern region of the United States, and because of a whole series of historical events, they really are entitled to establish a separate country, the Republic of New Africa, that's sovereign and self-governing. And this movement, which was initiated in Detroit back in the 1960s, is one that led to a number of conflicts with the FBI, federal government, and other things, caused a lot of problems. One of the leaders of that movement was the late mayor of Jackson, Mississippi, dear friend and colleague of mine, Chokwe Lumumba, who before he became mayor was a legendary lawyer who represented those who were regarded by the society as the most extreme kinds of revolutionary activists. And his tactics and strategies in the courtroom landed him in hot water over and over again. On one of those occasions, when he was seeking admission to the Mississippi bar, they challenged his admission, claiming that he advocated the quote unquote peaceful overthrow of the United States of America. It was ridiculous. And he was able to overcome that. But I cite that only to say that insurrection can be in the eyes of the beholder. And sometimes that can be used opportunistically to try and target certain people who, whoever the powers that be may not want to have opportunities. It can be used to exclude them. And I don't think we really want to go down that road.
I mean, was we see the legislation in your legislature, Terry. It just, I guess for me, the law is supposed to, you have to apply it fairly so that even with the people you don't agree with, the people you don't like, you want them to be treated fairly. And there's just something about all of this that that's made me distinctly uncomfortable. Not letting the people decide. I've always, just 2000. I mean, I am still shook, if you would, by the Bush v. Gore decision, which I think really sent us on this road to where we are now. And it's just awful because the courts decided the presidency. And ultimately, Gore won the state if the recount had been allowed to continue, and he won the popular vote.
Mm-hmm.
But
Right.
the court stepped in.
Right.
And they nullified it.
I mean, so I guess, yes, normally you want the people to be able to decide, which is why George W. Bush should never have become president. Hillary Clinton should have been president. So we don't allow the people to decide for a number of reasons. But actually, I think there's an analogy here to the First Amendment. Normally, we don't want the government to put you in jail for speaking your mind. But if you yell fire in a crowded theater, the government can punish you for speaking your mind, for doing that, right? So there are exceptions to that free speech, and there are exceptions to the idea that the people should decide who to vote for president. And one of those exceptions is if you commit insurrection. And Dwight said, and it's true that and what Mark said too, it was pretty clear after the Civil War who had engaged in insurrection. But they passed that. They passed the 14th Amendment after the Civil War so that it couldn't happen again. And they were looking to the future. They were looking to have this exception. You're not going to elect somebody who has engaged in insurrection ever again. And yes, I know that people who hold power will say that just ordinary progressive activists are insurrectionists, they're rebels, they're terrorists, right? Terrorists. The Black Lives Matter were called terrorists years ago. So yes, those.
No, wait a minute. They're spied on by the FBI right now.
They're still listed as, oh, for God's sake! I thought that was under Trump. I thought that the FBI.
No. I mean, they're surveilled today.
Yes, and that's unjust, and that is unjust because they factually in the real world they are not terrorists, but it is not unjust to keep an insurrectionist like Donald Trump off the ballot because the 14th Amendment says he should not be, he cannot be our president.
Well, here's where I'm with you. I favor Donald Trump being prosecuted for subversion, treason, and after he's convicted, being disqualified from running for office of any kind. But I think that that's the appropriate way to hold him accountable, as opposed to just having there be a presumption that he has engaged in insurrection.
But there was no
type of a record.
Did you think that's why the court didn't touch that today? Or
I mean, the Colorado court did not exercise a presumption. It looked at the facts and concluded that it was more likely than not that he had engaged in insurrection. Now, I don't know, Mark, are you saying it's beyond a reasonable doubt? Is that why we need a criminal proceeding? Because a court is capable of weighing facts and determining, you know, by a preponderance of the evidence, whether he engaged in insurrection, you know, within the meaning of the 14th Amendment.
But he didn't have a trial, Terry.
I do have two questions, though, before you come in, Dwight.
Oh.
You know, well, no. Well, then answer that. Because my question, because I think we're getting to what the court did not touch, the high court did not touch today.
Yeah, when I say he did not have a trial, is that when you accuse somebody of an insurrection, the legal construct in this country is you have a right to face your accusers. You have a right to present your counter argument. You have the right to bring your witnesses. And then the court or the jury makes a decision based on the evidence. This didn't happen in this case. This was just somebody arbitrary looking at their interpretation of facts with no counter argument. And so they became the judge and the jury in this situation, the accuser and the judge in this situation, which is the very opposite of how the law is set up. So that's why it becomes so capricious and so arbitrary, is that if your standard becomes your opinion, then everybody can have a standard because everybody got an opinion. And so each one of the states will make that determination about somebody who they either deem as a threat or perceive as a real insurrection, somebody who's led an insurrection, or somebody who they just see as an enemy of the state or enemy of their positions. And so, I mean, you open the door to chaos in that situation.
But Dwight and Attorney O'Neill and Attorney Fancher, Dr. D, if you will, it appears that the court avoided that question of insurrection. The high court, not Colorado, this court. You know, I mean, and it seems that's kind of what.
For those reasons.
I mean,
because
well, for those reasons, Dwight. But then I want Terry to jump in too, because I think you have something to say as well. Terry.
So, right, I'm trying to remember the procedural, how it worked in Colorado, what the procedural standard was. Was it that Trump's attorneys decided to seek a ruling as a matter of law, and they lost that ruling and it went to the Supreme Court? I think, in other words, I think the reason he didn't have a trial is not because the court denied him a trial, but because he wanted a ruling as a matter of law. Mm-hmm. Whatever the facts are, Your Honor, I can't be kept off this ballot. And that is what the Supreme Court said, because what they said was, we haven't had an adjudication on the facts. Yes, we haven't seen that. And we can't adjudicate the facts until Congress passes a procedural mechanism by which the facts can be adjudicated. And I go back to my cynical argument. I think that they know Congress can't do that. So here's the Supreme Court saying, you know, we can't remove him from the ballot until something impossible were to happen.
Well, I mean, Mark, were you about to say something?
No. What Dwight described was what's generally regarded as due process, and it's really, you know, as was stated, not really the role of an appellate court. You know, any court that is reviewing what was done at the trial court level to rule on anything for which there is not a record. And so in this case, where there were not findings of fact, where there was no record developed really of whether he engaged in an insurrection or not, at the Supreme Court level, they're not able to begin finding facts. That's not their role. The facts have already been established, and their role is really to look at whether the law is being correctly applied. And so they're not going to get involved in trying to find facts that were not found at the trial level.
Well, let me bring on Reverend Dr. Todd Urey Esquire. I think we've got you. What do you make of this ruling by the court today?
Well, in some ways, it's not surprising. One, because as I just heard Mark mention, you don't have a finding of fact that an insurrection actually occurred, either by way of a congressional determination to set the process, which Terry speaks to, or insurrection as a federal criminal violation would have to be prosecuted by the U.S. Attorney's Office. And there has been no such prosecution for insurrection, although there are other prosecutions ongoing from either special counsels, from DOJ, kind of acting in the role of a special U.S. attorney. So I think that's the first issue. The second issue, though, is I think this is why the court is going to have to protect the integrity of its presence. That to deem it proper that a state Supreme Court could remove someone from the ballot for a federal office meant that it would be a free-for-all. And quite honestly, some of the states that have been very regressive in protecting voting rights or other civic engagement rights would really kind of have a bit of a field day, kind of creating chaos. And I think that's why you ended up with a per curiam, basically a unanimous decision on that fundamental question. But then you have a break within the court where the three liberal justices say that the court actually went beyond what it was asked to do and started forecasting, almost giving hypotheticals that we would have in law school, to kind of say this would be the pathway if the facts were this, when in fact they are not this. And so I think they, on one hand, made the decision that I expected. On the other hand, I think I agree with what Justices Jackson and Sotomayor and Kagan all kind of spoke to. And then, of course, you had Justice Barrett, who did not go along with the extension, but she kind of indicated that she didn't like kind of the infighting on the court. So net, yeah, we knew they'd keep him on the ballot. That settles all of the other state removals, the most recent of them in Illinois. So that question is now, I think, moot based on this decision. But it still doesn't deal with the fundamental question of Section 3 of the 14th Amendment is, did he commit insurrection? And I think that's only going to be determined not by the Congress, but by whether or not, per the federal statute, will there be a prosecution of Donald Trump on that charge?
Should Clarence Thomas should he have recused himself from this case, given his wife's involvement in January 6th, or because we have not, I guess, he's not been found, because former President Trump has not been found guilty of insurrection, is January 6th off the table?
Well, I don't know that January 6th is off the table. I think the way that they're trying to get to it is interesting. I think once the court rules on the immunity question, I think you may see some review of whether or not they can charge him with insurrection. The problem was he was the sitting president at the time. And so you're going to have that fight all over again. Now, whether or not Justice Thomas should have recused himself, I don't know that that's really, this isn't the case where I would push that. I would push it on the remaining cases, particularly around the immunity question. And the reason why is this was a unanimous court that said that former President Trump should stay on the ballot. So it would have been pro forma if he had recused himself, but it wouldn't have necessarily changed the outcome in any way.
So, I mean, Mark, what do you think? Should he have recused himself?
I think he should recuse himself from the black race. Yeah, I don't know. I mean, from this particular case, maybe not, but I agree. Maybe with respect to the issue of immunity, yes.
Okay, Terry O'Neill.
Mark, we don't want him. So
No, I think he should have his own species.
he and Ginny can have their own
Yeah.
species together. Yeah, I think he should recuse himself from anything having to do with the insurrection, and that's this too. And so when you say, you know, we need to adjudicate the question of the insurrection, I mean, actually, there was a trial in Colorado. He did defend himself in Colorado. The trial lasted 5 days. He had multiple opportunities to defend himself and meet his accusers and all of that. So he did get that. Whether the trial was enough, you know, maybe people could complain about that. But here's another little twist. By taking its sweet time to consider this immunity question, the Supreme Court is making it less and less and less likely that there will be time for a trial on the insurrection criminal proceeding before the election. And we know that Trump has himself said he will disband all of those trials against, he'll cut all of them off if he gets reelected. So the Supreme Court is, by extending the time, really making it more likely that Trump will not face consequences before the election, and that if he wins the election, he will never face consequences for his criminal behavior.
What about this timeline? I mean, what do you make of it, Mark, Todd, White? Because it has given the former president a whole lot of space.
Well, then that's the role of democracy. That's the role of the American people. It's like Mark said, if the American people want him as their president, the majority of them, he has every right by constitutional law to become the president. And that's not the business of the Supreme Court or the legislators or anybody else. That is what democracy is. Democracy is the people choose. Now, whether you agree or not with their choice is a different proposition. But the fact of the matter is, he can only become president if he wins a process that's already been put in place, which is he has to win the majority of the electoral votes. And if he does win the majority of electoral votes, then for whatever reason, he becomes the president. And that is what democracy is.
Yeah, I agree with that 100%. And I think that it's important because as much as those of us in this conversation, you know, shudder at the thought of him being president again, the fact is that if he is prevented from becoming president when the majority of the people want him as president, then they don't get an opportunity to grow. Whatever the threat is that we fear or that we're concerned about festers, it remains. You know, it's frustrated and it will explode at some future time. If they have him as president and all of the bad things that we think will happen, then they learn from that. Or at least we have to hope that they will, and they grow. If they don't grow, then that's on them. But I think people have to have the full opportunity to have that experience. And I don't worry ever about whether people like Trump are going to get justice. I know God's going to take care of that. I don't sweat that at all. We may not see it and we may not experience it, and you know, we'll miss out on the fun of that, but it will happen. I don't worry about it.
Well, I mean, how is this going to shape up the election? I mean, because this happened the day before Super Tuesday. I mean, you can't make this stuff up. Or is this just happenstance, Dwight? What did you say in politics? There are what, acts of God and what? Conspiracies.
Conspiracies and acts of God. They, I think that what's important to understand about all of this is that Trump is the people's choice. And whether or not you agree or disagree with the people, it is their choice. And because a group of us believe that he's the wrong choice, it becomes self-righteous for us to believe that he has no right to be elected because he's not our choice. And we become as contradictory as those who we are accusing of being anti-democratic. We become our own hypocrites if that becomes our position. And sometimes, as Mark says, you have to step out the way and let the people learn for themselves if they, in fact, are wrong. I mean, and I think in 1938, 1939, Adolf Hitler was Time's Man of the Year, Person of the Year. And before that, Mussolini was their Person of the Year. And sometimes you have to step back and let history become the arbitrator of people's decision.
Terry, that resonated with you.
Yeah, I mean, I think a couple of things. First, the Supreme Court's actions have enormous. I think they do have not enormous, maybe, but enough influence over people's choices. So today, the New York Times headlines is all about how Trump is ahead in the polls and so which suggests that, yeah, Trump today is the people's choice. But it's likely that if the Supreme Court were not putting its thumb on the scales for him, that he might not be the people's choice when come November, when it's time to actually make a final decision. If the criminal case against him were allowed to proceed, many people might change. Looking at it, they might change their minds. We don't know. Yeah, if he is the people's choice, of course, we will have to deal with the fallout of that. Remember that the fallout of Time magazine anointing Adolf Hitler the Person of the Year was 12 million civilians murdered in death camps. And to be clear, Trump has promised to create concentration camps for migrants who are escaping conditions in South America that were created by the United States and our white patriarchal capitalist system. So just to be clear, we know where Trump is headed. He's told us,
Right.
what he's going to do.
And just for the record, Biden is supplying arms to Israel as they drop them on millions and millions and millions of people.
Yeah, I know.
And we can't be inconsistent with our moral outrage if that's the case. With Trump, most of that is speculation. With Biden, I don't understand why we're not. The same crowd that's concerned about Trump becoming a tyrant. I don't understand why the same crowd is not calling for Biden to be tried as a war criminal.
Yeah, I think you're right there. Actually, I think that the supporting the genocide in Gaza is reprehensible, and it's something that this country does all the time, over and over and over again. So,
well, I mean,
they're not mutually exclusive, right? We've given this dichotomous assessment that somehow or other we cannot have human rights accountability and criminal culpability in the same conversation, even though we're talking about two different people who are going to be competitors in the next election. I think this is really a test of the system. And if the system says that there is accountability for criminal acts, then we have to make sure that the system upholds that commitment. That's to Dwight, your point. Also on the human rights stage, there has to be a system that says, all right, if there are war crimes, then there has to be accountability. Here's the issue. The U.S. has chosen not to leave itself subject to the jurisdiction of the World Court because that's kind of the rules of the game, right? Trump has used the ability to lean in with these appeals and these delays. And here's what he's going to test, right? This is where we got to figure out if the system's going to work. And who's going to get harmed on the way? What is our acceptable level of collateral damage for the harm? If the experiment goes bad, Trump gets reelected, he attempts to pardon himself, which is the next test, because if he is able to push that and follow the lead of Prime Minister Netanyahu to try to reframe the authority of the Supreme Court so that he can remain in power, then I hear we have to test the system. The question is, What is our acceptable level? If this is a combat assessment, you know you're going to take some casualties. How many casualties are we okay with before we say at some point there has to be a more urgent and stringent intervention, because the protecting of innocent lives must always reign supreme if we're going to have a system of justice at all?
Well, I want everyone to stay on for the second hour of the Santita Jackson Show as we pull and really analyze this decision that the Supreme Court made that will allow former President Trump to be on the ballot in all 50 states and territories. I've only got about 90 seconds left, and you will have them, Attorney Mark Fancher, since you've got to leave us. Attorney Fancher.
I don't have much more to add other than to say that we are in an incredible moment. I think that while it has been a rocky and unpredictable and crazy ride up to now, it's going to get even crazier in the months to come. I continue to hold on to the opinion that's not shared by many that Donald Trump and Joseph Biden will not be the nominees for their parties. I think that we're in for some real surprises, and that has very much to do with the fact that neither one of them serves the empire very well, and that the oligarchy will see to it that proper caretakers of the empire's interests are positioned to be commander-in-chief.
And what did you say? The president and vice president are the errand boys, errand girls for the oligarchy, for the elites?
That's exactly right.
Something to be said for that. Something to be said for it. I wish they were still the voice. I wish they were the voice of the people, but it's my experience that you are correct. Do we have the power
And
to
you are
change that?
and you are an enemy of the state.
Always. Well, when you go against the oligarchy,
Yeah.
you are an enemy of the state.
Mark.
You know,
So you could never be our president.
I will never. Well, that's why Reverend Jackson couldn't, because he was asked the question, "What do you want?" Not Time didn't just ask him the question. The power brokers asked him the question. He said, "I want to end poverty. I want to end war. I want to establish peace." And they laughed at him. I was sitting there. Well, there it is. Stay tuned for the second hour of Keepable Eye. No. Whoa, this is what happens when you're on the air 7 days a week. The Santita Jackson Show. Woo! Oh, my goodness. Here on AM 950 Radio, the voice of progressive Minnesota, and the Santita Jackson Show YouTube channel. Terry, I'm here every day. Oh, my gosh. And then the Santita Jackson and Friends Facebook page. Sending you much love, Mark. Stay tuned for the second hour of the Santita Jackson Show.